Namaskar. I'm Dr. Nalini Avinash Wagmari. This is my brief information. Presently, I'm working as a associate professor at Tilak Maharashtra Vidyapeeth. Today's our topic is related to Privy Council. Then, what is the Privy Council? Its functions, its work system, as well as its importance in the Indian legal system. Let's see briefly in this lecture. Before the Indian independence, in establishing the administration of justice, the Privy Council played an important role indeed. It is to be noted that the Privy Council delivered justice to the people without any discrimination, and its decisions were based on the principle of natural justice and fair play, and also on equity. All the judicial institutions were under the shadow of the Privy Council. According to MKN, in full and MKN, Lord Heldon of the Privy Council had an association. According to Lord Heldon of the Privy Council, had an vocation to describe the nature of the Privy Council's jurisdiction. In the words of Heldon, he stated that we are not ministers in any real sense. We are a committee of Privy Councillors who are acting in the capacity of judges, giving a advice to His Majesty, but in a judicial spirit. The sovereign gives the judgment himself and always acts upon the report which we make. Our report is made public before it is sent up to the sovereign in council. It is delivered in a printed form. Then jurisdiction of the Privy Council. Thus, the nature of jurisdiction of the Privy Council was advisory in nature. Though the Privy Council was the last court of appeal, but it had functions of judicial advice to His Majesty regarding the action to be taken in case under appeal. The Privy Council used to make recommendation to the King in Council, and finally the King in Council was to exercise its royal prerogative of justice. Those days, it was settled position that King in Council always accepted the advice of the Judicial Committee of the Privy Council. Unless advice of the Judicial Committee of Privy Council was anonymously passed by its members, it could not be sent to the King in Council for decision because there was no provision for dissenting opinions of the members. The Privy Council was empowered to hear appeals and petitions arising from the decision of the courts in British colonies. In other words, the Privy Council was the last court of appeal and competent to answer ultimately the questions of colonial law. Whatever colonial colonies are there, the Privy Council has the appeal to King in Council, and King take the final decision. So the Privy Council had wide jurisdiction to decide the appellate matters related to the right of property, including the political and legal right, which were at variance from one province to another provinces. While delivering a historical speech on the extent of jurisdiction of Privy Council during the deliberation of the law reforms in 1820, Lord Brougham commented that the Privy Councillors determined not only the question of colonial law, plantation cases, but also sit as the judges in the last resort of all price cases. The Privy Council deals with a variety of cases covering a vast area of colonies. In most matters, the law involved was foreign to the Judicial Committee of Privy Council. The difficulties were greater as different colonies had different laws. Then, composition of Judicial Committee of Privy Council. There was a judicial committee to work within the jurisdiction of the Privy Council. However, the members of the Privy Council were to be drawn from the following officers, namely Chief Justice or the Judge of the King's Bench Court, Vice Chancellor of England, Master of Rules, Chief Justice of the Court of Commissioner, Lender or Judge of the Court, Chief Justice of the Court of Exchequer, Judge of the High Court of Admiralty, Judge of the Prerogative Court of Lord or Bishops of Canterbury, Chief Judge of the Court of Canterbury, etc. Then Composition Judicial Committee of Privy Council, the first Lord Commissioner of the Great Seat of Great Britain, and 2 members were the Privy Councillors, to be appointed by the King. It is clear that the Parliamentary Act 1833 provided a high degree of judicial minds to the Judicial Committee of Privy Council by introducing these high-grade judicial officers from different hierarchy. Further, the Privy Council to India or to any of the dominions, 2 Indian assessors could be appointed on a salary of £400 per annum. However, such assessors had no right to vote. It is to be noted that the entire appellate jurisdiction of the Privy Council was to be exercised by the Judicial Committee of Privy Council. The special leave to appeal could be granted by the Privy Council in civil matters involving a substantial question of law. It is to be reiterated that the Judicial Committee of Privy Council here matters only on reference of appeals or petitions made by the King in Council in this regard. The Judicial Committee of Privy Council was to hold its findings with recommendation to the British Crown. The decision of the Judicial Committee of Privy Council was not in the form of judgment, but it was in the form of suggestion to the King as to what was appropriate to be done on the principle of justice and fair play in the given case. The historical record shows that the King always accepted the suggestions and recommendations of the Judicial Committee and delivered the judgment in the same terms. So, King considered the advice of this or recommendation of the Privy Council. Then appeals from the courts in India. Whether it was a decision of Crown's Court or the Company's Court, an appeal was to lie to the Privy Council as of right. Thus, from the Indian point, the appellate jurisdiction of the Privy Council may be summed up under the following heads, namely, appeal from decision of Mayor's Court, appeal from decision of Recorder's Court, appeal from decision of Sadar Adalat, appeals from decision of Sadar Adalats of Madras and Mumbai, appeal from decision of the Supreme Court also. Then one by one we check. Appeal from decision of the Mayor's Courts. By the Charter Act 1726, the Mayor's Court was established in the presidency towns, that is Mumbai, Calcutta, and Madras. And appellate jurisdiction of the Privy Council was also extended for the first time to Indians. The decision of the Mayor's Court was appealable before the Governor General and Council of Settlement. It was regarded as a first appeal. However, second rather final appeal led to the Privy Council, that is King in Council, if the value of the subject matter of the suit was more than 1,000 pagodas. The limitation of preferring second appeal was 14 days from the date of judgment delivered by the Governor General and Council. Here the time and the subject matter also mentioned. Then appeal from the decision of Recorder's Court. When the Mayor's Court was replaced by the Recorder's Court at Madras and Mumbai, the appellate provisions were incorporated to perform appeal to the Privy Council, that is the King in Council. However, in 1800, a Supreme Court was constituted at Madras in place of Recorder's Court. The appellate provisions was, as stated, was maintained. The King and Council had a right to refuse or admit an appeal or alter such decisions. Appeal from decision of Sadar Adalats. In terms of Settlement Act 1718, the appellate provisions was made to prefer any appeal from the decision of the Sadar Adalat in Bengal to the King in Council in such civil matters which involve subject matter value not less than 5,000 pagodas. However, no rules were framed regarding the manner of making appeal except the aforesaid pecuniary limit. The Settlement Act 1781 had also enhanced the status of the Sadar Divani Adalat in Bengal by constituting it into a court of recorder. Then appeal from decision of Sadar Adalat of Madras and Mumbai. Regulation 5th of the Madras Code of 1818 devastated the Sadar Divani Adalat at Calcutta from the appellate jurisdiction to hear appeals from the Sadar Divani Adalat of Madras, and consequently an appeal from the Madras Sadar Divani Adalat could be preferred directly to the King in Council, and there was no restriction as to a appealable amount. In Mumbai, the right to appeal to the Privy Council was regulated under the Regulation of 5th of 1818. However, earlier it was required that the value of appellate matter be 5,000 pagodas or more. But this restriction was removed by the Regulation of 5th of 1880. So it's depend upon subject matter and the amount also. Then appeal from decision of the Supreme Court. The mayor's courts at presidency towns were replaced by setting up of Supreme Court by Regulating Act 1773 and the Judicial Charter Act 1774. The appellate jurisdiction of the King in Council remained unchanged. Therefore, an appeal from the decision of the Supreme Court could be preferred to the King in Council, Privy Council, if the value of the subject of dispute was not less than 1,000 pagodas. However, in civil cases, an appeal was required to be made before the Privy Council in form of petition, and it was to be moved in the Supreme Court for granting leave to appeal before the Privy Council. Such petition was to be presented before the Supreme Court within 6 months from the date of pronouncing the judgment in terms of Section 18 of the Regulating Act 1773. But in the case of criminal matters, the Supreme Court had the absolute authority whether to grant permission to make appeal before the King in Council or not to grant the same. So higher authority given the Supreme Court. Then the appeal to Privy Council against the decision of the Indian High Courts. It is to be noted that by means of the Indian High Courts Act 1861, the High Courts at presidency towns that is Calcutta, Mumbai, and Madras were established. Consequently, after passing of the said Act, the Supreme Court and the Sadar Divani Adalat in Calcutta, Mumbai, and Madras were abolished. The decision of High Court in civil matters was applicable to the Privy Council if the value of the subject matter was not less than 10,000. Or High Court issued certificate declaring that the case was fit for preferring an appeal to the Privy Council. Then only they have to send that case. A criminal appeal to the Privy Council from any sentence or judgment of a High Court made in exercise of its original jurisdiction, or the High Court declared that the criminal matter in hand was fit one for preferring criminal appeal to the Privy Council. Then King in Council power to grant special power to the appeal. So the right to appeal to the King in Council was available under the stipulated conditions, but the power to grant special leave to appeal was reserved to the sovereign function of the King in Council. Thus, when the High Court refused to grant necessary certificate or leave, the King in Council could grant special leave to appeal in civil as well as criminal law. The experience revealed that in civil matters, the King in Council was more flexible while granting special leave to appeal than in criminal matters. The King in Council could grant special leave to appeal if the matter involved substantial question of law or public importance. King in Council power to grant special power to appeal in criminal matter, the approach of King in Council was more restrictive. The special leave to appeal was, however, granted where gross miscarriage of justice had been seen. Gross miscarriage of justice, spelling this wrong. Gross miscarriage of justice had been seen. There were large number of criminal cases in the British colonies, and granting of special leave to appeal would have meant suspension rather than postpone of the sentence or execution of punishment. It would have caused undue delay between the commission of offense and execution of punishment, and deterrent effect of criminal justice system would have been rooted out. Thus, the attitude of King in Council could not be criticized as threshold. Again, this approach of Privy Council found support in Ibrahim versus Rex, as it was observed that leave no appeal is not granted except where some clear departure from the requirements of justice exists, nor unless by disregard of forms of legal process or by some violation of principles of natural justice or otherwise substantial and grave injustice has been found done. There must be something which in the particular case deprives the accused of a substance of fair trial or the protection of the law. In the same way, Ray versus Joy Kirsten Mukherjee, the Privy Council had occasion to consider special leave to appeal from the decision of the Sadar Nizam Adalat at Calcutta. In the instant case, the accused was convicted for the offense of forgery. However, accused sought permission to prefer an appeal on the ground that justice had not been done to him. He was refused special leave to appeal on the following grounds. So, special power to appeal. It would involve investigation and a fresh appraisal of entire evidence. There was no petition seeking leave to appeal till the time from any colonies. The effect, rather, result of granting special leave would defeat the very purpose of criminal justice. However, the Privy Council recommended that justice would be done by exercising the royal prerogative of granting pardon to the accused. In another case between Arnold versus King Emperor, the Privy Council, speaking through Lord Shaw, said that it is very clear that the Judicial Committee is not a court of criminal appeal. The committee had no power to interfere with the sentence awarded unless there is a gross violation of principle of criminal justice, which appears prima facie in the case in hand. Then appeals arising from the decision of the federal court. It is to be noted that the Government of India Act 1935 provided establishment of the federal court. The decision of the federal court was appealable to the Privy Council if the case was decided by the federal court while exercising its original jurisdiction, and leave to appeal was not necessary, and in any case with the leave of the federal court of His Majesty's Council. It is pertinent to mention that the old judicial system of appeal from the decision of the High Court to Privy Council was continued even after the establishment of federal court. Then abolition of judiciary of the Privy Council. In the background of the Government of India Act 1947, the jurisdiction of the Federal Court was extended by passing of the Federal Court Enlargement of Jurisdiction Act 1940. Thus, the Federal Court was conferred with the power to hear appeal arising from the judgment of High Court, and no special leave was necessary in this regard if the appeal was brought under the provision of the Code of Civil Procedure 1908 and with special leave of Federal Court in other cases. Subsequently, in the context of India, the appellate jurisdiction of the Privy Council was completely abrogated in 1949 by passing the Abolition of Privy Council Jurisdiction Act 1949. This act came to force on 10th October 1949. After Independence Act introduced, and through that act, the Privy Council was abolished. According to N.V. Paranjape, the pending appeals were transferred to the federal court except those which the Privy Council could dispose of before the inauguration of the Indian Constitution. With the coming into force the Constitution of India on January 26, 1950, the federal court was replaced by the Supreme Court of India. Then the Supreme Court of India was given wide powers, and it was regarded as the highest court of Indian soil. So the last case adjudicated by the King in Council was that of N.S. Krishnaswamy Iyengar versus Penumal Gandan from Madras. Thus, the function of Privy Council in respect of the Indian judicial system came to an end. Then what is its contribution to Indian legal system? The Privy Council played a significant role in development of law in India. As Professor M.P. Jain rightly said, the Privy Council served as a bridge between the Indian and the English legal system for 2 decades. The comments and interpretation of law by the Sadar Divani Adalat, Supreme Courts, and the High Courts cause a great hardship to the lawyers as well as to the litigants. However, Privy Council became the unifying force in the judicial administration in India. The decision of the Privy Council had enriched the Indian judicial system because it had always focused the principle of natural justice and fair play while delivering its verdicts. Thus, the Privy Council contributed in the development of the civil law, property law, personal law, and commercial law by harmonizing the conflicting provisions. So, it's played a major role in Indian legal system. On the day of the abolition of Privy Council, Mr. K.M. Munshi rightly observed, the British Parliament and the Privy Council are two great institutions which the Anglo-Saxon rule have given to mankind. Anglo-system rule have given to mankind. The Privy Council during the last 2 centuries has not only laid down law, but also coordinated the concept of rights and obligation throughout all the dominions and colonies in the British Commonwealth. It has been a great unifying force and forces Indians to become the instrument and embodiment of the rule of law, a concept on which alone we have based our democratic institution, which we have set up in our constitution. We have based, at that time, the Privy Council was the final judicial authority. Thus, it had occupied the role of sole interpreter of the federal constitution. Then the Government of India Act 19 conferred the power to the Privy Council to hear appeals against the decision of the Indian courts. It has opportunity to incorporate the principle equating justice, good conscience in application laws in various fields. The Privy Council has played a remarkable role in founding the Indian Constitution free from political driven interest. Then, even after the establishment of the Supreme Court of India on January 26, 1950, the decision of Privy Council are cited and recognized. The judgment of Privy Council are held in high esteem and they are still binding on the high courts in India unless the same has been overruled by the Supreme Court of India. However, in respect of personal laws and decision of the Privy Council were found to be irrelevant, which were against the Indian norms. Thus, the decisions have been criticized. It is true that the councillors of Privy Council had very little knowledge about the Hindus and Mohammedan personal law. The solicitors they engaged in England to pursue the matter before the Privy Council were ignorant about the Indian custom and uses. Therefore, they were not in a position to plead the matter of their clients successfully. On such point, the decision of Privy Council became impracticable and could not become a precedent, as mostly they were overruled by the Supreme Court of India. So, in practical point of view, the seeking of justice from Privy Council was an expensive. So, merits and demerits are there. So, here in demerits, the Privy Councils was an expensive affair involving huge expenditure on the parties because of 1,000, 5,000, 10,000 pagodas are there. Consequently, the appellate remedy for the Privy Council was available only to rich and the influential parties. And poor parties were deprived of this remedy mainly due to financial reasons. Moreover, the place of sitting of Privy Council was located in India and most of the cases related to council sit in England and cases related to India solving is a very practically difficult one. The Privy Council was the highest court in respect of the Indian judicial system. It gave the impression that the proceedings before the Privy Council would be prejudicial to the interest of the Indian litigants, which cause fear among the Indians. So this is all about Privy Council, its functions, provisions, appeals, merits, demerits, and preferences. So you can refer these books. Even the AC Three-Party Indian Legal System and Constitutional History, Central Law Publication, Allahabad 2009, where there are more details mentioned. You can refer that one. I also refer for PPT. I also refer that book. Thank you very much. For other books, you can refer the MP Jain book, Brij Kishore Sharma's book, and V.D. Mahajan book also. Thank you.